After discussing the chapters of the appeal and revisions, we are going to proceed the next chapter, that is with reference to the uh, bail and bonds. This is very favorite chapter of the examiner. Not only examination point of view, but the practice point of view also. This is very important as me because after completion of your uh, 3 years or 5 years course, when you start your practice, you realize this the provisions under these chapters are very beneficial to you people, since they are the bread and butter provided at the initial levels, and no technical procedure or the provisions are provided. Very simple aspects are provided, and in order to understand the provisions, we'll start with the chapter 30 from the chapter 33 from the criminal procedure code, that is with reference to the bail and bonds. Now, section 436 to section 450 of the criminal procedure code deals with this aspect. Before we go to the, the other provisions under the CRPC, we must understand that the concept, the term bail is not defined under the criminal procedure code. In general sense, bail is a kinds of security given by the accused person against that he will be attended in the court of law. So I'm underlining the last word, that is everything is for the attendance in the court of law. So it's one kind of security given by the accused person. Now, when we use the word security here, so far as this chapter is concerned, security is in terms of the either in money, that or in terms of the some other person, that we call as surety. So security again divided into two parts. One is monetary security, and other one is the surety. That means some other person stand surety on behalf of the accused person and taking the responsibility that the accused person will not attend the court. It is his responsibility, that he will be responsible, and it is his duty to brought the accused person in the court of law. So that this is called as surety. So far as the monetary relief that is concerned, that is called as the security. This is one kind of the monetary security, that while passing the order, sometimes court may say the accused person may release with the personal bond, and that personal bond along with the monetary security, so that that the person will attend the court, because he is afraid that the amount which he has paid in the court of law will be forfeited by the court if he will not attend the court proceeding. So this is one kind of the provisions has been provided so far as the criminal that is bails are concerned. Now uh, uh, with this initial discussion, if you go to the origin of the what is this meaning of call as bail, then you will realize that the word bail comes from the French word that is we call as the bailer. That it means the person means the to deliver or to give. That means to deliver or to give. So it's a bail is to deliver to give. That is a surety, and the dictionary meaning. If you go to the dictionary meaning, then you realize it's an some kind of security is given by the accused person, or the assurance is given by the accused person, or the guarantee is given by the accused person that he will be appear in the court of law. So this is one kind of the security, one kind of the ensure, rather one kind of the undertaking given by the accused person that he will attend the court proceeding. So this is just an introduction part so far as the bail is concerned. With this initial introduction discuss, let us discuss with the main aspects in respect of the bail, and we realize that there are two authority in India so far as the criminal procedure is concerned, which has the power to grant the bail. That is, one is by the police officer and other is by the courts. So while discussing this discussion under this chapter, we will classify the kinds wherein the bail can be granted by the police officer, and wherein the court, in under which circumstances court has a power to grant the bail under the chapter. Again, the provisions of the bail again classified and divided into two parts. There is different kinds of provisions provided in respect of the what do you call the offences in respect of bailable offences or bailable cases, or in case of non-bailable cases. So there is a different provisions is provided for the bailable offences and the non-bailable offences. So before we start with the what is meaning of the bailable and non-billable aspects, we have already discussed and defined, especially section 2A, which say the billable offences has been are those offences which are specifically provided in a first schedule as a billable offences, and what is non-bailable offences? Generally, except bailable offences, the other offences called as non-bailable offences. However, in order to understand the characteristics of the bailable offences, one of the characteristics of the bailable offences is that in case of the bailable offences, that uh, the the court can grant the bail to the accused person. I'm not talking about as of right, but generally the court will grant the bail if the offence is bailable offences. However, the criteria for granting the bail in case of non-bailable offence is something different. There is some other rules, and the regulations will be applied in case of non-bailable offences. Similarly, generally, I'm not saying all the offences. Generally, the bailable offences are those offences for which the punishment is less than 3 years. Again, this is the most important aspect. Rather, this criteria of the punishment make the classification between the bailable and non-bailable offences. So, in order to simplify which offences are bailable, which offences are non-bailable, however, please bear in the mind that the court or the I'm sorry, not the court, but the government has a power. Even certain offences are bailable and to which the punishment is less than 3 years. The government may classify that offence as a non-bailable offences. But generally, I'm talking about the offences for which the punishment is less than 3 years. That offences will be called as the bailable offences. And in case of the non-bailable offences, exactly opposite, as I have already told you, that the main aspect is that it is not the case that when there is an offence is non-bailable, bail will not be granted by the court. No, granting or rejecting the bail, for that purpose there is a different rules and regulation. There is a different criteria is provided under the section. That is a total discretion. So therefore, don't be under the impression only because the offence is non-bailable, it doesn't mean the accused person will not get the bail. It is the total choice of the court to grant. It depends upon the so many things like the which offence he has committed, the gravity under which situation he has committed offence. Similarly, whether the accused is a hardened criminal, that is a record criminal, or whether he is having the prior record. There are so many things that there is a chance of fleeing from the justice. All these aspects are the ground for rejection of bail. So only because offence is non-bailable, this is not the ground for the rejection of the bail. So coming back to the non-bailable offences, again, non-bailable offences are those offences which are shown to be non-bailable in the Schedule 1, and again the criteria of the punishment. In case of non-bailable offences, the punishment is of 3 years or more than the 3 years. So this is what the initial difference. So and initial difference and the rules in respect of bailable and non-bailable offences. Now, apart from this, uh, uh, the distinction of bailable and non-bailable offense is again based upon the gravity of the offenses. Along with the gravity, then the other factors also play a very vital role. Like we'll say the previous conduct of the person, the health condition of the person. Why? Because if suppose person is sick, then some benefit will be given to the sick person. Then we call that the sex of the person, whether he is a male or female. In certain cases, I'm saying in certain cases, the justification is given to the female or the children, and therefore sex, the prior context, that is we call it antecedents. All these aspects are being considered by the court while classifying the offences. So with this introduction, then the broad classification, with this, let us discuss the different types of bail granted by the police officer and the court. Uh, as I have already told you, there are two authorities which has a power to grant the bail. One is the police officer, and second one is the court. Now let us discuss these two categories. One first category which we are going to discuss first, that is the power of the police officer to grant the bail. So uh, again, in case of the police officer, the power of the police officer, we will divide this discussion in two parts. That is when there is a warrant and when arrest is made without the warrant. Rather, most of the sections we have already discussed while discussing the initial discussion of the CRPC. So when we talks about the powers of the police officer in respect of the granting the bail, then again this particular aspect is divided into two parts. When arrest is made with the warrant and arrest is made without the warrant, because rules are totally different. Let us take the first aspect, because there are several sections which deals with confirm the power of the police officer to grant the bail. Especially there are eight sections, of course, apart from this there is which give the power to the police officer when they have arrested the accused person without warrant, like section 42 is there, 43 is there, section 56, 59, then section 169 is there, section 170 is there, then section 436 and 437. Uh, uh, this particular provisions deals with the powers of the police officer to grant the bail, and those offences which are specified under Schedule 1, especially column number 5. And when it talks about the police officer, that is the power with the warrant, that is grant the bail with the warrant. Then if you remember, we have discussed, especially there are two aspects, that is section 71 and section 81. When there is an endorsement by the court itself, then police officer can grant the bail to the accused person. So with this, let us discuss what are those powers. Firstly, we'll discuss the power of the police officer to grant the bail when the arrest is made without warrant. Firstly, section 42 of the CRPC. We have discussed this aspect already. That if the accused person or if the police officer has arrested the person without the warrant and on the suspicion, that suspicion should be he has committed the cognizable offences, and after asking or inquiring the police officer, if that particular person is refused to give his name and address, or the police officer believes that the name and address is given by the accused person is not correct, then in order to ascertain the correct name and address, the police officer can carry out the arrest of the accused person. This is the power with section 42 given to the police officer to arrest without the warrant. Now, the same section has given the restriction, so far as the arrest is made, that it cannot be detained more than the 24 hours. And we are aware, if it is detention has to be made by the more than 24 hours, the procedure is provided, and the same rule is applicable as it is applicable under section 167 of the CRPC. That is, he has to produce the accused person before the magistrate, and then he has to take the further the police custody. Same rule is applicable so far as section 42. So in short, section 42 is applicable when the in order to ascertain the actual name and the correct address of the person. So under section 42, again the restrictions are provided. It provides that if suppose the accused person has disclosed the correct name and address, and if the police officer is satisfied that the name and address disclosed by the accused person is correct, then he has to release the accused person by executing the bail and bond. This is the first power with the police officer. Same case in case of section 43 also, that it provides that if suppose the accused person has been arrested, and it is the duty that without unnecessary delay he has to produce before the nearest magistrate. And if suppose however the police officer realize that his function has been over, or his intention to arrest was over, and he get the entire aspect of detailed knowledge, then he can release the accused person by exercising the provisions under section 43 of the criminal procedure code. Apart from this, section 56 and 57 and 59 again deals with the power of the police officer to grant the bail. Especially Section 56 provides that if the police officer has been arrested the accused person without warrant, whether with his for the irrespective of any offences, then by exercising his own power, the police officer may uh, he has an authority under Section 57. He may grant the bail to the accused person, or if he realizes the granting the bail of the accused person is not proper, then you are aware that the provisions of Section 57 deals with the aspect that it is gives the mandatory duty on the police officer who has carried out arrest that he has to produce the accused person before the nearest magistrate. That is what the Section 57 says. That is, it should not be more than the 24 hours. So illegal detention should not be more than the 24 hours. So what I'm trying to show to all of you that if the police officer has arrested the accused person on the charge of the commission of offence, then he has a twofold choice. Under Section 56, he may grant the bail to the accused person within his own discretion, or if he requires the accused person further custody, then under Section 57, he may take the accused person to the magistrate, and magistrate he may again take the further police custody. That is by using the power under Section 167 subclause 1 of the CRPC. Now, apart from this, now Section 59 again correlate with the Section 56. It says that the police officer has its extra while using the extraordinary power of the uh, to grant the bail. He may, in exceptional circumstances, he may, within his discretion, either he may discharge the accused person while taking the bond of the bond from the accused person also. So these are the three aspects which are provided in Section 56, 57, and 59 of the CRPS. Apart from this, there is another provisions under the Criminal Procedure Code which is provided, that is with reference to Section 169. Now, this is the special provisions so far as the granting the bail of accused person is concerned. Please bear in the mind the earlier rights of the police officer which we have discussed, that is before the investigation. Here the investigation is not commenced. That accused person is arrested by the police officer on the suspicions or after receiving the information or on any other grounds, and the power we have discussed to grant the bail. Now, so far as this provision for granting bail under Section 169 is concerned, this is after the investigation. It means the person has been arrested by the police officer, whether that is as per Section 41, that too without warrant. Then he has uh, take the accused person to the nearest police officer. I'm sorry, the nearest magistrate. Nearest magistrate granted the police custody times and time, and thereafter the investigation has been conducted by the police officer under Section 157 to the rest of the sections. However, after completion of investigation, so say for instance there are four accused person in one of the offense, and police officer has arrested. Section 41 came into picture, produced before the magistrate. 57 came into picture, no bail granted. That is, he has not exercised Section 56. Investigation started. 157 has been there. Now, after the collection of the evidence, what he found that out of four accused person, there is no evidence. Rather, he is not able to collect the evidence against the one accused person, and therefore, instead of sending the charge sheet against all four accused person, what he will do that he will only send the charge sheet against the three accused person, and in respect of one accused person against whom there is no evidence has been collected by the investigation officer, then he may send the report to the magistrate stating that there were four accused person, but out of four accused person only we are able to get the evidence against the three accused person, but we are unable we are unable to collect the evidence against this fourth accused, and therefore the honorable court may kindly release this accused person. Apart from this, so far as the power of the magistrate, I'm sorry, the police officer is concerned, while exercising the power under Section 169, the police officer, instead of taking this accused person, that is the fourth accused person, to the magistrate, he may simply take the bail, that is the bond, or grant the bail to the accused person, and the person will be released by the police officer while exercising the powers under Section 169 of the criminal procedure. So this is something extraordinary power given to the accused, or that is the police officer. Apart from this, Section 170 is another aspect, that is the power with the police officer. And this, please bear in the mind, Section 170 came into picture that uh, the offense is registered against the accused person. And say, for instance, we'll continue the same example, that there are four accused person, as we were discussed while discussing 169, and uh, now the police office offense is registered, police officers carried out the investigation. But if the offense is bailable, now this is what the characteristics of section 170. If the offense is bailable, then the police officer has the authority to grant the bail to the accused person under section 170. So the difference between 169 and 170 is that in case of 170, it's a offense is bailable. In case of the 169, the offense is non-bailable. Or sometimes in case of the available offense also, 169 report will be there. That is not the question. And then we'll come to the last aspect, where the police officer can grant the bail in respect bail without, when the arrest is made without warrant. That is with section 437. Now you will be surprised, how come the section 437, when everything 436 437 deals with the powers of the court, where is the provision? Then you will realize subclause 1 of section 437 deals with this aspect. It speaks that when any person has been arrested for non-bailable offences. Now this is extraordinary power, and this can be used by the police officer in exceptional cases. In case of the bailable offences, 1670 is there, while in case of non-bailable offences, 437 subclause 1 is there. And it speaks that whenever any accused person has been arrested by the police officer, that is without warrant, and and the offense is non-bailable, then please bear in mind, don't write the police officer here, the officer in charge of the police station. Now, this power to grant the bail under section 437 subclause 1 is with the officer in charge of police station. He has the authority to grant the bail even the offense is non-bailable offense. Of course, while granting the bail, he believes that there is no sufficient ground to believe that the person has committed an offense to which the sufficient offense. Then the officer in charge of police station will grant the bail. However, he has no authority to grant the bail if the offense is punishable with death or life imprisonment. So when we talks about section powers of the officer in charge of police station under section 437, he can grant the bail if the offense is non-bailable, if the offense for which the punishment is not death sentence or the life imprisonment, or if he believes that there is no sufficient ground to proceed with the accused person, then the officer in charge of the police station may grant the bail. Apart from this, so this is all about the power of the police officer to grant the bail when arrest is carried out without warrant. Now, when you talks about the power of the police officer, now we discuss the powers of police officer to grant the bail when they have arrested with the warrant. And there are only two sections. Rather, we can't say the two sections, but section 81 is the part and parcel of section 71. It speaks about that we have already discussed section 71. It said the bail granted by the police officer if there is a warrant issued by the court. So section 71 came into picture if the honorable court has issued the warrant, and on that warrant the court has made endorsement. If you remember the wording under section 71, if the court has mentioned the endorsement that after in case of arrest of the accused person, accused may kindly be released on execution of the bail or the bond or the personal bond or the surety of rupees certain amount. So when the amount warrant is issued by mentioning the certain amount, that is the endorsement made by the court, then under section 71, the police officer after arrest, he can release the accused person by taking this either the casualty or the surety or the security as directed by the court. So this is the power with the police officer when the arrest is carried out with the warrant. But the requirement is that there should be an endorsement in this behalf by the honorable court. Now, I will take the pause here. When we start the practice, because see, we are discussing the bail, non-bailable offences, bailable offences, or everything is there. But while discussing the warrant, we have not discussed what is the concept called as bailable and non-bailable warrant. Non-bailable warrant is we have already discussed. But in case of bailable warrant, there is no such kind of particular section or the particular definition is provided. But when you enter into practice, sometimes court issue the bailable warrant. Now, what is which section deals with the bailable warrant? Section 71 is the concept. Indirectly deals with the. I'm not saying directly. Indirectly deals with the bailable warrant. Why bailable? That the police officer has the power to grant the bail, and therefore it's called as the bailable warrant under section 71. That is the power. And next power that is under section 81. Section 81 came into picture. If this warrant, so the difference between 71 and 81 is that 71 under the warrant under section 71 is issued by the court within his own jurisdiction. That means if the accused is residing in Pimpri and the Pimpri court has issued the warrant, then section 71. However, if the accused person is residing outside the jurisdiction, then and the court has directed to release the accused person with the endorsement, then section 81 came in picture. Then in such a case, the court will direct the police officer outside the jurisdiction to carry out the arrest and to release the accused person while executing the bail. That same procedure, but the only section has been different. That is what the provisions so far as the powers of the police officer is concerned. Now come to the second part of our discussion, that is the power of the court to grant the bail. Now, so far as the power of the court to grant the bails are concerned, sections 436 to section 450 deals with this aspect. Of course, there are other sections also that we'll discuss. That is, we call it the supplementary or auxiliary sections, wherein the court has a power to grant the bail. That we'll discuss while discussing this aspect. Let us discuss the first power, that is with reference to the honorable court has power to grant the bail. Now, we have discussed the hierarchy of the courts. Here also, we are going to discuss the certain aspect with reference to the hierarchy. Uh, so far as the provisions of the bail by the magistrate and the bail by the session court and the high courts are concerned, there are different parts or different provisions have been provided. I will explain you. So far as the power of the bail by the lower court, that is the magistrate court or chief judicial magistrate courts are concerned, that is provided under section 436 and 437. Again, we'll discuss the amendment carried out with reference to section 436A. This is a special amendment carried out. But in case of the bail granted by the magistrate, the provisions are provided in section 436 and 437. Now, so far as the uh, power of the High Court and the Session Court is concerned, those provisions are provided in section 438 and section 439 of the Criminal Procedure Code. Now, what is these provisions? I will deal with this. Section 436 gives the power of the judicial magistrate first class, second class, or chief metropolitan magistrate, all these courts to grant the bail in case where the offence is bailable and to which the police officer has not released the accused person on the bail. So when the police officer has produced the accused person before the magistrate and the offence is bailable, then while exercising the power under section 436, the magistrate court can release the accused person on execution of bail or sometimes personal bond, that is we call as personal bond, PR bond, or by taking the cash surety or directing him to deposit the surety also. So this is the power under section 436. So far as the section 437 is concerned, this is the power of the court in case of non-bailable offences, and 437 exclusively deals with the power of the judicial magistrate when the offence is non-bailable. So when offence is non-bailable, the rules are not easier as to the bailable offences. In that case, while granting the bail, the court has its own discretion. Court may grant or court may reject the bail to the accused person. So in both the circumstances, when accused person is brought or when accused person is appear before the court of law. I hope you understand brought and appear. Brought means when there have been warrant of arrest and the court has, there is a police officer has taken the accused person and and he has been brought by the police officer. Appear means the moment the summons has been served, he appeared and he made an application. So in case of the non-bailable offences, he has to make an application to the court of law, praying that and mentioning that why he deserved to be granted the bail. However, however, please bear in the mind when the offense is punishable with imprisonment of life or death sentence or imprisonment for more than 7 years, then the judicial magistrate first class has no power to grant the bail in this respect. Now, I will take a pause. Why? Because when we enter into practice, these kinds of practical problem we people are going to face, and you are also going to face. If you go to the Schedule 1, you realize there are certain offences for which, of course, in the Schedule 1 they have mentioned that the judicial magistrate first class has the power to conduct the trial and to convict the accused person. Like I will take the example, section 467, 468, and 479. I'm sorry, 471. If you go through, you will realize the punishment for all these offences is sometimes 10 years, sometimes life imprisonment also. But if you go to the court, which is competent to conduct trial, you will realize it's a judicial magistrate first class who has a competent trial. However, if the while granting the bail, look at the provision under section 437. It says the judicial magistrate first class cannot grant the bail if the offense for which the punishment is more than 7 years. So, one hand, the power is given by the Schedule 1 to conduct the trial, but the same provisions are saying you can't grant the bail. So, this is something we this is something which is unbelievable, and therefore there is always clashes. Time will become that someone took this matter to the Supreme Court, and Supreme Court will direct, or the Parliament will delete this, because when the court has a power to conduct the trial, why not to grant the bail? Because the limitation is provided that if the offence for which the punishment is not is more than 7 years, the lower court cannot grant the bail. That is the limitation under section 437. However, However, this rule of granting the bail if it is more than 7 is not applicable to the certain categories. That is, if the person is below the age of 16 years, or if she is a woman, or the person is sick or suffering from any some disease, then the court will grant the bail. Or in other special circumstances, the the court can grant the bail to the accused person. At the same time, when the accused person is brought before the court and he is praying for the bail, and if the sufficient surety or security is not taken given by the accused person, then it's a power, the police officer, that is the court, has a power uh, to refuse the bail of the accused person. So this is what the difference between section 436 and 437. And another provision has been inserted by an amendment under section 436A. That is, it provides that if the offence under which the accused person has been charged and he is in jail and bail has not been granted to the accused person, and if he has undergone one half of the imprisonment for that uh, alleged section or alleged offense, then as of right, he is entitled to get the bail. I will give the simple example. Now, with this, again will point out you one thing, that is there is one judgment I have quoted in the Justice Gajendra, that is just I'm sorry, Justice Bhagwati. He has criticized this our system of the bail. Why it is, and rightly also, because see, what is our system? That suppose Justice Bhagwati said our system of the bail is a property oriented system or money oriented system. Why? Or it is rather suffering from the property oriented approach. Why I am saying this? Because see, what is the procedure? If suppose accused person has been arrested for offense on the charge of the theft, and the amount of theft is more than 10,000, what is like 1 lakh rupees. He has been arrested. He brought before the magistrate. Since it is non-bailable offences, the lawyer made an application under section 437 mentioning that ground 1, 2, 3, 4, and court granted the bail. What is the procedure? He has to either deposit the 15,000. If the court says the accused is released by executing the sureties, one surety of rupees 15,000, or depositing cash amount of 15,000, or personal bond of rupees 15,000. So what is the procedure? So everything is turn and running around the money. So the court in India believes that so only because if the person that is accused person deposit the amount in the court of law, he will attend the proceeding. Or if he having the property, then the accused person will be released on the bail. So that's what the Justice Bhagwati has rightly criticized. We are property oriented rather than the human oriented. Why I'm saying this? If suppose the accused person uh, he committed the offense of theft, the maximum punishment of theft is 3 years, and he was presented as per section 57 before the court. The court granted the magistrate custody, but he never applied to the bail because the problem that is the property oriented approach of the system. That what is the procedure? There has to be someone who will stand as the surety. He must have the surety, must have the property. But the problem with this accused that he don't have someone that who will stand as surety. Neither he have money. That is what rather he has committed the offense. Therefore, that is the offense of theft. So, take the example. He is in jail from 2016. We are in 2014. The punishment for offense is 3 years, and he is under trial. Yet the trial is not commenced under trial for the 4 years. That is more than 1 year than the actual punishment, and therefore the provisions have been made under section 446A. That is, if suppose the person who is charged with the certain of allegations, and if in the jail, one half of the maximum punishment provided for this offense, he has to be released on the bail. And that's why whatever the Gajendra Garkar has said is absolutely correct, absolutely the correct wording, that we are property oriented. uh, this is what the the present position in the Indian judiciary. Apart from this, if you talk about section 436, it says if the accused person is custody in the jail and bail has not been granted by the court, it is mandatory on the court to decide the trial within 6 months. But in reality, no one follow this rule. 6 months is the criteria to complete the what do you call it, the bail, that is the trial with the accused person in bail. Up, After this, come to the next aspect called as the anticipatory bail. Section 438 deals with this aspect. Please bear in the mind, anticipatory bail, that is bail under section 438 and bail under section 439. In these two sections, the power is only with the session court and the high court. The lower court, that is judicial magistrate first class, chief judicial magistrate, metropolitan magistrate, chief metropolitan, they don't have power to grant the anticipatory bail. Rather, there is no concept, there is no power with this all this court. Only two courts are empowered: High Court and Session Court. Of course, the Supreme Court is there, but the High Court and Session Court, as of right, there are. Now, let us go. What is this anticipatory? The word anticipatory comes from anticipation, that is to afraid of, and there are certain rules of anticipatory bail. What is anticipatory bail? That this bail application can be filed by the person only when the arrest is not carried out. Now, what is the meaning of arrest? We have already discussed. But there are certain aspects with what you call as the person in custody. If the person is in custody of the police, then he is not entitled to file the bail application. That is called as anticipatory bail application. So, what is the meaning of the person in custody? There are several judgments because the concept is not defined anywhere. There are several judgments which define the concept called as person in custody. Uh, Bombay High Court has also delivered so many judgments. Now, what are those aspects? We call talks about the anticipatory bail. When accused person there is apprehension, he may approach to the court, and court will grant the bail to the accused person. However, while granting the bail, the court has to consider the certain factors like the chance of flee from justice accused person, the security of the attendance by the accused person, the anti-incidents, the nature of the offences, the character of the person will play very vital role. Please bear in the mind, anticipatory bail can be filed only in respect of non-bailable offences. If the offence is bailable, there is no such kind of provision for filing of the anticipatory bail, and that too with the session court or the high court. However, if the accused person has been arrested, the person is not entitled to file uh, the bail application against the anticipated bail. The moment person is arrested, his power under section, that his rights under section 438 comes to an end, and he has to file the regular bail application uh, under section 439 of the Criminal Procedure Code. So there are several judgments in this respect, so far as anticipatory bail is concerned. Now, there is one problem in respect of the anticipatory bail. That is, sometimes it happens. Most of the times, the question raised, what is the tenure of the anticipatory bail? Why I'm saying this? And when you enter into practice, especially, you will realize this is the problem uh, of the tenure, and that confusion has been again increased by the judiciary, that too by the Supreme Court. Why I'm saying this? Say, for instance, a lady lodged the complaint under Section 498A, and fortunately for her, FIR is registered. The moment FIR is registered, police officer went to the house and they carried out the arrest to the accused person. This is arrest without warrant. 56. And they produced the accused person before the magistrate. 57, 59. And the magistrate granted the bail. Just now we had discussed. 437. Bail in case of non-bailable offences. Now this bail is for till the end of the trial, if it is regular bail application granted by the court. However, in case of non-bailable application, the problem is what will be the tenure of the non-bailable application. Why? Why? Because the procedure for non-bailable application is that the police has not arrested, and therefore before arrest they will apply and court grant the bail, and then the bail is granted. They present before the police officer, but no actual arrest is carried out. There are several judgments. There is one judgment in the year 2011 by the Supreme Court, case from Maharashtra itself. Ex-Minister of the Maharashtra, Siddharam Maitre versus State of Maharashtra. Supreme Court has said once anticipatory bail is granted, it will be continued till end. There is no need to another bail granted, because see, it is a bail granted by the higher court. How can the lower court will describe the correctness of the bail? Now, this is continued up to 2018. However, in the year 2018, in a Satpal Singh case, again the Supreme Court has something. It is said it is not for the till the end of the trial. It's a discretion of the court. Once they appear before the court they have to approach to the court, and they have to take the bail from the application. So what I'm trying to tell you, that there is a QS, and do you know what, there is one the petition pending before the Supreme Court. What will be the actual tenure of the anticipatory bail? But till that day, we'll have to refer this either to the Siddharam Maitre or the Satpal Singh. So with this, let us go to the regular bail. So what is this regular bail? So once the accused person has been arrested, and offence for which the punishment is more than 7 years, lower court can't grant the bail. That is what we have discussed, section 437. Then what is the remedy? If he is in jail, he has to approach to the higher court, that is the high court and the session court, and he has to file application for bail under section 439. In that case, the session court of the high court, considering the gravity of the offences, the nature of the offences, the circumstances under which the offences has been committed, all these aspects, the court will either grant the bail or refuse the bail. If the session court refuses the bail, then the aggrieved person may approach to the high court. See, this is not an appeal. This is not an appeal. This is an application. So, if the session court rejects the bail, there is no provision for the appeal. But again the refusal by the session court, he may go to the high court, stating that will be rather called as the second bail application, not an appeal. So there is no appeal from the session court to the high court, and if the high court also rejected, to the Supreme Court of India, but it is not called as an appeal. It's an only application. So these are the powers of the court to grant the bail in case of the offence that is triable by the session court or by the law. That depends upon the punishment. Apart from this, the provision, there are other provisions in which the court has a power to grant the bail, especially Section 330 of the CRPC deals with the bail to the lunatic. because if the person is unsound mind, lunatic, suffering from some bodily or mental disease or unsound mind, then the rule applicable to the general accused, that is ordinary accused, will not applicable. Then in that case, under section 330, even though offense is serious in nature, but considering the physical or mental difficulty, the court can grant the bail while exercising the power under section 330 of the Criminal Procedure Code. Another the procedure in case of the power in respect of the offense, that is court of contempt of the proceeding, that is under section 346. If the offense is punishable, or if the offense is punishable under section 175, 178, 179, 180, and 220 of the IPC, that is contempt of the court order, and the court decided, instead of proceeding 345 of the CRPC, that is the regular trial, let us grant the bail. Then, while exercising the power under section 346, the court can grant the bail subject to the condition, if the offence for which the punishment is only fine, then only the court will grant the bail. Similarly, the power under section 360. 360 is the special provision. If suppose the offender is the first offender and he has committed the offense under special circumstances or unavoidable circumstances, then in such a case the court has a power to, instead of sending the person in jail, he may on the admonition, the court may release the accused person by granting the bail under section 360 of the Criminal Procedure Code. And then the most important aspect, that is with reference to the power under section 389. This is called as post conviction bail. Now this is the power with the appellate court. Now when this power will be exercised, let us discuss the history. See, for instance, accused person has been arrested on the charge of the offense of theft, and the lower court, that is judicial magistrate first class, convict the accused person for 1 year. Please bear in the mind, if the offense for which the punishment is less than 3 years, I'm saying less than 3 years, has been awarded, I'm not saying provided, awarded by the court, then the same court has a power to grant the bail till the date of filing of appeal. So this is the extraordinary power. If suppose here the accused person is convicted for the theft for 1 year, the moment he was convicted, he made application to the same court stating that, sir, please grant the bail till till uh, the period of appeal, that is under section 389, and the same court will grant the bail subject to condition if the punishment is less than 3 years. Okay, less than 3 years. So if this bail is granted, then there is a, as per Limitation Act, 1 month period is there for the appeal. He file appeal to the appellate court, because the force of lower court of bail order with till the filing of appeal. Then the moment he file appeal, again he has to make an application under section 389 to the appellate court, that, sir, my tenure of the bail is granted by the lower court is till today, kindly grant. Then in such circumstances, the appellate court will grant the bail while exercising the power under section 389. This is called as the pre that is the after conviction bail in the appellate court. However, if there is a monetary order passed by the court, that is conviction plus fine, conviction plus compensation, compensation, then the appellate court will not suspend the conviction unless the person has paid that amount, or the amount as directed by the court. That this is the pros and cons in 389. Come to the next and very important aspect so far as bail is concerned. That is we call as the default bail, section 167. Very interesting, and we have already discussed what is this default bail. Generally, as we have discussed, if the offence is punishable more than 7 years, if the session court or the high court has a power, and if it is less than 7 years, in case of non-criminal offence, lower court. However, 167 is the only section in which, irrespective of the punishment, irrespective of the who is tribal, the judicial magistrate first class has the power to grant the bail. Therefore, it's called a default bail. Why? See, what is the procedure? If suppose accused person is arrested, then he has to produce to nearest magistrate 57, 58, 59. Time to time he may grant the custody up to 14 days. 167 is there. and after 40 days he is in jail. Now let us take the example: accused person has committed the offense of murder, and he is in jail. Now, what happened when he is in jail? Section 116 subclause 2 provided the investigation of the matter has to be completed within 60 days if the offense for which the death punishment is less than 3 or up to the 3 years, and if the offense for which the punishment is more than 10 years up to death sentence, then investigation has to be completed within 90 days. What is meaning of investigation has to be completed? That charge sheet has to be filed under section 173. Let us take the example: accused person has been arrested under charge of murder on 1st January. So by default, if the accused is in jail, I'm talking about, if he's on a bail, no provision will be applicable. If he's in jail, then only 167 will be applicable. If he's in jail, he has not released by the court, rather his application has been rejected. Now today is the 19 days, because for death more than 10 years, if the charge sheet is not filed on 19th date, then he can make an application to the judicial magistrate first class, trial by the session court. Magistrate will be allowed the application under section 167. Therefore, it is called as the power of the magistrate. That is called I'm sorry, the default bail. This is extraordinary power with the judicial magistrate first class grant the bail. So this power can be exercised by the court. There are several judgments from which we have to count the period of the bail and all these aspects. What is the tenure? Everything has been provided, but law says from the date of arrest till 60 or 90 days. This is what the provisions for the bail. So far as the provisions of bond are concerned, we'll discuss in very short video after some time.